digital competition law is in its final stages. A high-level inter-ministerial committee may take a decision on recommendations within a month's time. The committee has spoken to various stakeholders, including content creators, app developers, and tech giants. The debate about whether India should consider going for ex-ante regulations at this stage is picking up. From big tech companies to smaller players, many stakeholders have raised concerns about such a move and its implications on India's fast-growing digital market. Shivani Bazaz brings us this special report.
The Committee on Digital Competition Law, formed by the Ministry of Corporate Affairs, is working on a draft Digital Competition Act. Even though the contents of the draft are not known yet, it is likely to be influenced by the European Union's Digital Services Act. While the European Union has notified Digital Services Act, which comes into effect in 2024, countries like United States, Australia, South Africa and the United Kingdom are also in the process of bringing in additional regulation for the digital economy. In India, the Parliamentary Committee on Finance had recommended a separate ex-ante law on the lines of European Union. Ex-ante is Latin for beforehand. So legally, any law that comes into effect before the occurrence of a situation is called an ex-ante law. So why are ex-ante laws important?
When you come up with an issue like protection of privacy, if you leave that to an ex-post regulatory system, then it's inevitably too late once there's a big data breach or something like that. So an ex-ante rule, whether it's through a law or a code or a contract even with the companies, that they will protect consumer data in a certain way, that can be an ex-ante provision.
While one view is that there is an urgent need for ex-ante regulation, many experts believe that India's existing framework has enough safeguards to regulate big tech.
The CCI actually has enough powers today to be able to investigate digital economy companies, as is evidenced by the fact that they have over 25 ongoing investigations. Given that the CCI has that power, ex-ante is not really needed, right? So neither is the EU model, the DMA, which is the Digital Markets Act, which is yet untested and hugely prescriptive. I think it will impact both investment and innovation adversely. Intervention should happen not in nascent markets.
Various stakeholders like the Internet and Mobile Association of India and 58 smaller stakeholders, including the Cyber Cafe Association of India, sent a representation to the MCA making a case against the ex-ante digital competition policy.
If you look at our economy, we are not Europe. We want to encourage startups. We want to encourage entrepreneurship. So we should not bring in a blanket rule which can be detrimental. And do remember that ex-ante regulations are very new. It has not been tried and tested. In fact, even in EU, the adoption would be from 2024. And there is also a concern which is raised that EU is not entrepreneur friendly.
While the debate continues on whether or not ex-ante regulations should be brought in at this point, it remains to be seen if the Ministry of Corporate Affairs can bring the new law to the Parliament in the winter session this year, or would want more time for deliberations on the recommendations of the high-level inter-ministerial committee on digital competition law. In New Delhi, this is Shivani Bazaz.